Good to go.
All right. Welcome, everybody. I'm attorney Justin Randall with Hooper Law Office, and our topic today is on probate in general, sort of scary stories about probate, but also questions like, do my children inherit my debt when I die? Or if you're the child watching this, do I inherit my parents' debt when they pass away? So before I dive into the topic too much, just a couple quick reminders. This is interactive, so if you have any questions that come up, you can submit them to the Q&A box and I'll see them come up. And then also at the end of this, you'll receive a couple things from us in an email. One is our things that go through probate and things that don't go through probate, sort of handy chart that you can use as a reference tool. And then also a place for you to let us know that you'd like us to reach out to you to set aside time to meet. So we offer complimentary initial consultations. We schedule them for about 2 hours. So if anything we talk about today, or you just have general estate planning questions or things that need to be reviewed, it's a really good use of time. Again, so you'll receive some things on that at the end. And then if you would like us to set aside time, let us know. And again, they are complimentary. So, and then just a reminder to everybody before I forget, next week is our Appleton public seminar on wills versus trusts at the DJ Bordini Center at the Fox Valley Tech here in Appleton. If you're looking to sign up for that, sign up at estateplanningAppleton.com. There's limited seating for that. So, if you're interested in attending, we have a 2 p.m. and a 6 p.m. session. For whatever works better for you, and please sign up there if you're interested. So we'll go through a lot more information on that, general estate planning information than we do in these, where it's a little more focused topics. But okay, so again, the main topic today is on things that people maybe have heard about probate that are maybe untrue, or maybe are true in other states, but definitely not here in Wisconsin. A lot of times it's sort of the advice that somebody's friend or family friend told them, or things that they had heard, or the ever infamous things I looked up online kind of statement. So there's a lot of things with probate that just are not true relative to what people have heard about it, especially in Wisconsin. So to get started, though, I mean, the first sort of thing that obviously we have as the title for this is, do I inherit my parents' debt, or do my children inherit my debt when I pass away? And there are some states where there's what's called filial responsibility laws. What that basically means is, for certain types of debt, usually medical, related debts, things with like long-term care, those sorts of things can be inherited by the child, who, it's their responsibility to take care of their parent, is the idea behind these laws. My understanding is it's generally different for things like credit card debt. That's not generally part of it, but medical debt is the big thing. In Wisconsin, we don't have those types of laws. We do not have filial responsibility laws. So in Wisconsin, the child does not inherit the parent's debt unless they obviously co-signed on something. They're then responsible for it too, but that's different. You having a medical bill that was not paid, if you don't have enough money in your estate to cover that, the child is not suddenly responsible for the overage. They have to take a loss on that. Now, there are certain types of debt that don't just go away either. So, I mean, things like mortgages, attached to specific properties, it's not just going to go away. I mean, it may still be able to come, the bank can still foreclose on the home if the family's not willing to assume the mortgage, right? Or if the home is sold, they'll still have to pay off the mortgage first before any overage goes to the beneficiaries. But if the mortgage is somehow worth more than the value of the property, then it would not be the responsibility of the family or the personal representative or anybody in the estate to pay off that mortgage, or what was not already subject to the property. So good news there, kind of ripping that Band-Aid off right away, something you generally in Wisconsin do not have to worry about unless you've co-signed on a loan. But again, that is a little different, because then it's also your loan as the individual. Other myths with probate, other things that tend to come up as a lot of misunderstandings about probate or misconceptions with probate, is, when it's useful and when it's not, I think is a really common misunderstanding, or maybe just lack of knowledge around it. And a lot of people have heard really bad things about probate, maybe because of their own experience with it, or family members' experience, or family friends' experience with it. And, they've heard really bad things about it. And, probate is a tool just like anything else. So you want to use it for the right reasons, but, a tool has its uses. And with probate, really the biggest reasons you're looking at going through probate is, if somebody has, for example, minors that they need to name guardians for somebody. That's where probate is necessary, because the court needs to approve those guardians for the minor children. You can't just name it in a separate document and suddenly say, oh, by the way, that's who the guardian is. The court has an interest in making sure that the minor children have guardians who are fit. So that's a really, really common reason that somebody would need probate. You have minor children. Another really common, speaking of debt, really common tool for probate is when somebody has a deficit estate, right? So a deficit estate is where the estate actually owes more than there are assets and the value of the assets. So with that, you want to make sure that you're giving proper notice to the creditors. You're making sure that the personal representative's following all these steps, right? Somebody has a deficit estate, then the creditors are given notice, which they are in all circumstances, right? Anyway, even if it's not a deficit estate. But then those creditors have a certain period of time to come forward and file a claim. But if there's not enough assets in the estate to go around, it's still making sure that that personal representative then still did what they were supposed to do. They followed the procedures. They didn't not give notice to somebody who may have had a priority lien on something, right? So it just covers them and from their role as a personal representative, which, if you're unfamiliar with that term, is the same thing as an executor, right? It's just what we in Wisconsin call that position, is a personal representative. A third common reason for using probate intentionally would be that somebody has very specific planning that they need followed in their wills. So what I mean by that is they may have a child with supplemental needs or special needs that they need. They have a special needs trust in their will for that child. There's certain types of special needs trusts for spouses, for nursing home planning and things like that, that you may want to be set up for that individual. Well, this kind of goes into another myth with probate, but wills are only effective in the probate process. Wills do not direct non-probate assets. So in order for somebody's will to be followed properly and the provisions in that will to have effect, you have to start a probate for that. You can't just go down to the bank and say, hey, I haven't opened a probate, but I have this will, please follow the instructions in it. They would tell you to come back later with the right documentation. So wills have to, if you want wills to do anything, they have to go through probate. Another component of that, though, is that in order for the will to control the assets, those assets also have to potentially be subject to probate. So if you have everything payable on death, everything transfer on death or beneficiary designated, those types of transfers do not go through probate. They pay directly or transfer directly to the individual or entity listed on that beneficiary form. So if you want the provisions in your will followed and you don't want to leave it up to chance or up to the person you're leaving that money to split those assets accordingly, you have to make sure that certain assets are subject to your will by going through probate. So more often than not, it's the home is already going to be in probate because somebody just has it owned by themselves and is, when there's no beneficiary designation, when you just own it and you pass away, things go through probate. But the problem we run into a lot is they'll have all of their assets other than the home avoid probate. Well, this creates a really disjointed process because the personal representative, the one in charge of the estate, has obligations. They have to pay, make sure that they can try to pay expenses for the home, utility bills or realtor's fees or whatever it is while things are happening in the probate process. Well, if all the beneficiaries already have all the other money, they may not have access to those funds to actually pay those expenses. And that can be a really big problem for them because they're trying to do the right thing. They're trying to follow their role, but they have to, tell the court, well, look, there's no money in the estate to deal with this right now. We just have the home. Where this can be even more of a problem is when one of the when the personal representative, is one of the beneficiaries on one of those accounts. This creates a whole new set of issues for people. The first common issue that this creates is that the personal representative is maybe one of the beneficiaries, or maybe they're not, but somebody will leave an account to that person to pay expenses, right? They'll say, all right, use this to pay expenses so that you have money for that. Well, the problem with that is when you name someone as a beneficiary on an account, they own that money after you pass away. It transfers to them, not to the other beneficiaries you wanted. So if the will says divide everything to all these different people, but you only name one of them on an account, that person is under no obligation to split those assets accordingly, the ones that they've received as a beneficiary. As a personal representative, even if they wanted to split those assets accordingly, there can be reasons they can't. So if they're the beneficiary of that account and they then own it after you die, well, what happens if they have some sort of ongoing bankruptcy or medical debt, or expenses that are coming up, or they get sued for some reason, right? Or they're in a nursing home and they need to spend down for Medicaid purposes. They may not be able to share those assets with the beneficiaries the way it was intended. That is because under those circumstances, if somebody tries to transfer money away by gift, which is essentially what you'd be asking them to do, they can have penalties for that. It can kick them off of any benefits they're receiving. It can be called a fraudulent conveyance if it's a bankruptcy process, right? There are reasons they can't do that. So if you have a will and you want things to go a certain way, it's very important to make sure that the personal representative has funds in the estate to actually pay expenses so that they're not subject to that personal representative's personal liabilities. But also then you're not leaving it up to chance of, do they actually follow my wishes? Are they obligated to follow my wishes? Under a will, they are, right? As close as they possibly can, as long as there is money to go to those beneficiaries. They can't decide to not follow what the will says. So the biggest myth with probate is making sure that you actually, if you're having a will and you have assets that you want divided a certain way according to that will, that you actually make sure that those assets are subject to probate. The biggest myth we have is that wills help people avoid probate, which is just not true. I've even seen some, unfortunately, attorneys say the same thing where they'll say, when you have a trust, that the whole point of a revocable trust for a lot of people is to avoid probate. There's still a will with that trust. It's what we refer to as a pour-over will. The point of a pour-over will is to say that if something goes into probate by mistake, like they didn't title it properly, the account, or didn't have a beneficiary designation properly on that account, that will, the pour-over will, says take the probate estate and put it back in the trust. The trust is the beneficiary. So the biggest incorrect piece of advice I've seen from that, even from certain attorneys, is that it says a probate or a pour-over will helps you avoid probate, which is just not true. You still have to go through probate if you're using a pour-over will. So with probate too, one of the biggest misconceptions I think people have is how immediate that process will be, how quick someone will have access to accounts. So the personal representative, they can't, like I said, they can't just take the will down to the bank and say, see, I am the personal representative. Let me have access to that account so I can start paying bills. They first have to file the will with probate, and then the court will approve that person as personal representative so long as nobody objects to that appointment. And that process is not immediate. It can take upwards of a month in some circumstances. And in the meantime, any accounts that are otherwise subject to probate are temporarily frozen. Those assets are not liquid during that time. And that's to prevent somebody from doing something, with it, or, expenses to keep coming out when the estate hasn't been opened yet, things of that nature. So It's not as scary as it sounds, right? Creditors know they have to wait and get proper notice. They know that they have a certain period of time they're going to be given to come forward. So just make sure that the personal representative knows, though, that they still have to start that process. So in the meantime, though, if there are other expenses that, somebody would need access to funds for, that's where that can be frustrating for some people, is that somebody has to wait a certain period of time to get access through that account. So, with debts and things like that with probate, I mean, there's very good reasons for it, but being very careful about the provisions in the will, there are protections for beneficiaries. If somebody has a substance abuse issue, if somebody has creditor concerns or bankruptcy going on, right? Things like that. As long as the will is drafted properly, those assets can be protected for those individuals. So it's very important, though, that if you have a will to actually use it, make sure that those assets are subject to it. But if your goal is to avoid probate, be very careful about relying on a will to do anything for you, because you're going to end up with a very disjointed plan otherwise. One of the things we run into quite a bit with myths around probate, I think, is whether or not it is private in nature. To be honest with probate, it is potentially public. It doesn't mean that people are broadcasting this. It's not like the celebrity trials you may see where it's everybody's following it online or following it on the news or things like that. But the will is potentially public record if somebody wanted to receive a copy of it. This is how we know, what was going on in certain estates. This is how we know certain celebrities without, who had probate happening. We know what kind of assets they had, who their beneficiaries were. We know all of those things because reporters went down and requested copies of what's going on with this estate. So if privacy is a concern, probate is probably not the right tool for you. And this can be very concerning for people who maybe have not minor children, they're a little more protected, but younger adults who are maybe a little more at risk for certain, being persuaded to do certain things like investment wise, right? We want to protect those individuals. So if that's a concern, know that your will is potentially something that somebody could have access to, and they can look at the estate and figure out what types of assets existed. Again, if any questions come up, let me know. I can see the Q&A box and I don't see any questions yet. So let me know if those are, concerning or anything. One kind of last thing on the debt issue. Speaking of the children don't inherit the debt, the personal representative is also not personally responsible for the debt of the estate. So by naming someone in that role, you're not saying, oh, if I don't have enough money, they're responsible for the debt. Now, they have certain duties they have to, follow. They have to make sure that if there's funds in the estate, that they properly pay off any creditors, or if they didn't give proper notice to the creditors or intentionally withheld, notice from creditors, there are liabilities that they could have for that. But if they're following all the proper steps, then they themselves are also not personally responsible for that, that debt. So you're not, just like you're not asking the kids to pay it off personally, you're also not asking the personal representative to do that personally either. They're not personally responsible for that. So don't, filial responsibility or personal representative responsibility, it doesn't apply in Wisconsin. With that, probate myths come up a lot. Be very careful what you read online. Like I said, make sure that you're talking with an estate planning attorney if you have questions of your own. Like I said, we will send out that handout to you, and you'll receive a place where you can let us know if you'd like to set aside time for an initial consultation. Next week, like I said, is our Appleton public seminar. So we do have that'll be in person at the DJ Bordini Center in the Fox Valley Tech here in Appleton. If you do want to sign up for that, sign up in advance. Seating is limited for that. So that will be estateplanningappleton.com. Like I said, seating is limited, so just please try to do that in advance. And then after that, we actually have our next webinar is 2 weeks from now, and it's on estate planning for pets. So most people don't realize that you still have to potentially plan for what happens for pets after you pass away. Now, we all hope that we'll potentially outlive our pets so that we don't have to plan for that, but it's a possibility. So if that is of interest to you, please sign up for that as well. With that, I will let you all go, and I would say enjoy the rest of your day, but it's a little rainy here, so maybe don't enjoy the day outside. But otherwise, I will see you guys hopefully at the public seminar next week, and if not, the following week at the